keep everybody straight. The argument will be up on YouTube in a couple of days, so you can see how well you did. We've read the briefs, looked at the record, and we've conferenced the case, so we're familiar with the facts of the law. So when you begin your argument, just tell us what you would like for us to know. Mr. Green, you can begin.
Thank you, Your Honor. May it please the court and counsel, my name is Kyle Green. I represent the appellant in this matter, Mr. George Reed. The basic principle of our argument is that the state has failed to present sufficient evidence to establish that Mr. Reed was an accomplice to the actions of the drug sale of Eddie Flores to 2 undercover police officers. Now,
but counsel, he, at least in the latter instance, he met the middleman, handed over the drugs, and then he gave the officers, he gave the drugs to the undercover officers. That sounds like being an accomplice to me.
Well, I think that in order for you to be an accomplice, Your Honor, you have to be able to know that those drugs are then going to be resold as it relates to the facts of this particular case. So Mr. Reed maybe met with the middleman in this case, Mr. Flores, at the Circle K, handed him drugs, but he has to intend for those drugs to then be passed on to the undercover detectives. There was no evidence presented by the state to establish that Mr. Reed even knew that Mr. Flores was there with detectives, or that he was going to then pass the drugs on to those detectives or sell them, which would be required to establish that there would be sufficient evidence as an accomplice for Mr. Reed's criminal liability. Now, the statute says that you have to intend to promote or facilitate the commission of that offense, and that includes the additional step of knowing what's going to happen with those drugs. In this particular case, the state failed to present any evidence to establish that he knew that there was going to be further action taken by Eddie Flores once those drugs were in Mr. Flores's hands.
When you say no evidence, you mean no direct evidence. I mean, certainly there was circumstantial evidence that the jury could have used to find intent, correct?
I think that the state relies on circumstantial evidence in their response to our brief. I don't think that the circumstantial evidence that they answered with is sufficient to establish that. What they used for evidence was the fact that Mr. Flores was known to be a middleman in drug transactions in this apartment complex. And then they also used the fact that there was another drug transaction that took place that Mr. Reed was ultimately acquitted of as evidence to establish circumstantially that Mr. Reed was involved in drug sales for this particular incident that he was convicted of. So I don't think that there was.
Wasn't there also evidence? So didn't the undercover officers specifically ask to buy from Mr. Reed? And why?
Well, sure, but what we didn't have evidence of was Mr. Flores coming in to say that he communicated that to Mr. Reed, or that Mr. Reed had any idea that he was giving drugs to Mr. Flores to then give to detectives.
Don't we have evidence that the detectives heard Flores on the phone with referencing Mr. Reed, and then Mr. Reed shows up? Why can't we put 2 and 2 together with that information? I agree there'd be a problem with that first transaction in July, but this seems different since they specifically asked for Mr. Reed, and there seems to be evidence that Flores was on the phone with Reed, and then Reed shows up where the sale takes place.
And I agree with Your Honor that is the factual scenario of what took place. Where I disagree with Your Honor is that the action of Mr. Flores calling Mr. Reed, if that's really what happened, and again, we only have a kind of third-hand acknowledgement of that, is that Mr. Reed would have to know what was going on with that transaction. What we can speculate as to how many times Mr. Flores called Mr. Reed or any number of things that way. But what we don't have evidence of in the record is that Mr. Reed knew that Mr. Flores was requesting these drugs to then resell it. And that's what would be required to establish his liability under the accomplice liability statute.
Well, Counsel, are you saying that there has to be direct testimony and circumstantial evidence can't lead the jury to reasonably conclude that he's an accomplice?
I'm not saying that circumstantial evidence is not good evidence, if that's what Your Honor is asking. What I'm saying is that the evidence that was presented in this particular case was insufficient to establish circumstantially or through direct evidence that Mr. Reed was involved as an accomplice. And I would point out, too, that there was no expert testimony from the state's witnesses as to the quantity of this drug. What's routinely seen is that we have an expert who comes in and says, well, we have this much of this kind of drug. That equates to something that has to be more than personal use, and therefore it had to be sold. The state didn't present any evidence of that. All they heard was that these officers requested an 8-ball and how many grams that was.
Well, doesn't that evidence usually come in a case where there's just some possession of drugs and it's the possession of drugs for sale, and then the quantity gives rise to an assumption or that there's a sale, but we don't. Why would we need that here where there is an actual sale?
Because the actual sale is occurring from a third party, not the charged defendant in this particular case. The state needed to prove that Mr. Reed knew the purpose of these drugs was going to be transferred to another person. Had the state presented that expert testimony to say this is a huge amount of drugs or this is a small amount of drugs, whatever the testimony would have been, that would have established that Mr. Reed should have then known that these drugs were then going to be later resold. The state failed to present any evidence like that. If we were talking in terms of marijuana, for example, if we're talking pounds of marijuana that are being transferred, we can assume that that would be for sale. We don't have that kind of quantity in this particular case, and no testimony on the record established that this was a high enough or large enough quantity to then be deemed to have should have known kind of scenario that it was going to then be resold. And so what we have here is what the state would like to point as circumstantial evidence to be able to say Mr. Reed was involved. But in reality, their circumstantial evidence is nothing more than he's merely present, or if he did sell drugs, it was to Mr. Flores without any understanding that it was then going to be resold to the officers. And each one of those transactions,
you can't connect the dots through the phone conversations with the detective specifically asking to purchase from Mr. Reed, and then Flores contacting Reed, and then Reed showing up. Why can't we connect the dots that way?
Well, I don't think that a phone conversation, again, between Mr. Flores and Mr. Reed, which is that Reed knows that Mr. Flores is then giving those drugs to the detectives, or that he's going to resell them, and that he's an accomplice in helping that happen. For all we know, and all that was presented in the evidence, is that Mr. Flores wanted drugs, and Mr. Reed provided drugs to Mr. Flores. Not that Mr. Flores wanted drugs and then he was going to give them to somebody else. That's not established by the record at all.
Well, there's a record established that Flores is known as a middleman, just generally.
I don't think so, Your Honor. I disagree with the state's argument that he does, or that he is established as a middleman, or at least that Mr. Reed knew that he was a middleman. I guess I will correct my statement. I think the detectives testified that they knew that Mr. Flores was a middleman, but I'm not sure that any evidence would establish that Mr. Reed knew that Mr. Flores was a middleman. The detectives testified that they bought drugs from Mr. Flores on a number of occasions, but that has nothing to do with Mr. Reed's knowledge of what Mr. Flores was or wasn't. And the state uses the argument that they shared an apartment together, so therefore he has to know. But I don't think the record did establish that Mr. Reed knew that Mr. Flores was a middleman. I think the detectives tried to establish that they had bought drugs from him a number of times and therefore was a middleman, but the record doesn't indicate Mr. Reed had any indication of that.
What about Flores' or the detective's testimony that Flores told him that Reed waited around and had said that if Reed didn't like something, he would have driven off or something to that effect? Doesn't that suggest that Reed was there to monitor what was happening?
Well, I don't recall the specific quote that Your Honor is referencing as it relates to that. What I recall is that Mr. Flores indicated that he was going to make a phone call and then went and met with somebody in a van who only one of the detectives determined was Mr. Reed, and that the detectives were concealed from the van and didn't show themselves to Mr. Reed or whoever was in the van when Mr. Flores came back. So I don't think that there was testimony that indicated that Mr. Reed was checking up on or trying to observe any sort of third-party transaction that I recall reading in the transcripts. And if I'm misstating that Your Honor's question, feel free to ask me again.
No, that's helpful. Thank you.
And so at this point, I don't think that the state presented the evidence to be able to establish that he was an accomplice. In addition to the accomplice liability insufficiency of evidence argument, we also have argued that the particular instruction for the accomplice liability being liable for any reasonable actions that occur after it, we are also deeming that would be a due process violation due to the nature of the instruction being overly broad and without limitations. And I would point out that the state didn't address that in sufficient form in their response, so we would deem that the state has waived argument as it relates to that particular aspect. With that, Your Honors, if there are no further questions, I would reserve the balance of my time for
if
rebuttal.
I could ask you, if with regard to the instruction, so if you would be fine, presumably, if you just put a period after offense, if we just take out the language including any offense that's a natural and probable or reasonable foreseeable consequence. So your argument then is that at most they could have said he was Mr. Green was guilty of providing drugs to Flores, and that the jury would have had to have said, well, then it's a foreseeable consequence that he's going to resell it to somebody. Is that what your argument is?
I would agree that that's the argument, that it would be the steps the jury needs to take in this. I think that the way that the instruction is given to a jury, or was given in this particular case, establishes that it's overbroad and that anything could be reasonably foreseeable under the way that the language is written in the statute.
Was there any question what the state's theory of the case was here? I mean, wouldn't the jury just stop if the only theory was that that Mr. Reed was an accomplice in selling the drugs to the undercover officers? There wasn't some other theory. It's not like a felony murder case where it's an accomplice to burglary and a murder resulted, where we have to wonder about the foreseeable consequence. The only crime that was being discussed was the sale of drugs to the undercover officers, and the assertion by the state was that Mr. Reed participated or was an accomplice in that particular sale. So we're not really talking about some hypothetical other offense that was reasonably foreseeable from that transaction, are we? Sorry for the long question.
I would agree and disagree with Your Honor. I would assert that what the state's theory was, that Mr. Reed was an accomplice to the sale from the detectives. What our argument is that Mr. Reed was involved, if at all, with a sale to Mr. Flores, and then Mr. Flores then resold it. So the question would be whether selling drugs to Mr. Flores and then him reselling them is a reasonably foreseeable consequence of his actions. And I think that's where the instruction gets it wrong, because the state's theory was the detective sale, not the sale to Mr. Flores. And we know from the Brown case that was cited in our brief that the drug transactions are individualized or stop once the transaction occurs, and that they become its own transaction. And so the actions of selling to Mr. Flores is one specific thing, and then Mr. Flores selling it to the detective becomes another. And so at that point, I think the instruction becomes too overly broad, because you would have to establish that Mr. Reed knew of that second transaction.
And counsel, if we would disagree with you on the sufficiency of the evidence argument, can you still win on the due process instruction argument?
I believe so, Your Honor, because again, just for the reasons I stated previously, we're talking about a whole separate transaction that the jury was instructed in an overly broad manner that, excuse me, if they were given a proper instruction or a limiting instruction to understand what kind of actions or what kind of foreseeable consequences would be permissible, then Mr. Reed didn't receive a fair trial, and that violated due process.
Thank you, counsel. You'll have 4.5 minutes for rebuttal. Mr. Valenzuela.
Thank you, Your Honors, and good morning. May it please the court. My name is Michael Valenzuela, and I represent the state in this matter. Your Honors, sufficient evidence supports a finding that Reed aided his roommate Flores in selling heroin to undercover police officers and provided Flores the means to do so. It also supports a finding that he intended to promote or facilitate Flores's activities. The record thus supports the jury's verdict, and this court need not reach Reed's alternative argument about section 13303A because it simply does not apply in this case.
What's the strongest evidence demonstrating that Reed knew drugs were going to be sold to the undercover officers, as opposed to simply him selling or providing drugs to Flores?
Well, Your Honor, I think that it's at risk of not directly answering your question. I think it's important to remember that we don't look at this evidence of every single little factor, but we look at it collectively. And so, as we argued in our brief, collectively, the evidence was more than sufficient to prove Reed's intent to promote or facilitate this crime. But if we want to look at which factor probably stands out the most, it would be the phone call.
Give me 2 or 3 points that you say add up to intent to assist the sale of drugs to the detectives.
It would be first the fact that Officer Stevwing and Romo asked Flores to arrange a drug sale with Romo because they didn't trust anybody else. And when they did so, Flores didn't say, there's no evidence that Flores said, no, that's not my role. No, that's out of line. That's not what I do. He agreed to do it. And then the officers come and pick him up, and you can listen to the CD of the recording. It was admitted as evidence. The court has it as part of the record, where Flores calls Reed and essentially tells Reed, hey, I'm on my way with others to come and meet you. Where can we meet? And then, of course, they eventually do meet. They arrange to meet out in a public location to conduct this exchange of drugs so that Flores can middle the deal between Reed and the officers. I think it's important to note that while Reed tries to argue that this transaction between Reed and Flores, there's no way for the state to prove that knew what was going to happen for these drugs. The jury should have just believed that these drugs were for Flores' own personal use. Well, if that was the case, then why go into public and have this transaction out in public where it's much more risky, there's more risk of being caught, instead of just doing it in the comfort of their own private apartment where they lived together? That's another circumstance that cuts in favor of the fact that this is indeed a drug deal that's being middled by Flores. And then finally,
Counsel, can you explain why the jury would acquit in the first instance and convict in the second? Does that have to do with the evidence being better in the second incident?
Yes, Your Honor. If you compare the two incidents between the August sale for which Reed was convicted and the July sale for which he was acquitted, Reed takes a much more active role in the August sale. They actually have Flores talking to him about the sale. You see him not only, for the first sale, it was argued that he just kind of coincidentally showed up and then went into the apartment. Well, that wasn't the case for the August sale. It was a specific plan for them to meet and facilitate this exchange out in public. You also have the fact that for the August sale, the officers, as Reed's driving away, they're able to see into his van and they see that he's the only person in the van. So you have that element of exclusivity for the second sale, which the state wasn't able to prove for the first sale. The state presented testimony that both Reed and Flores walked into the apartment, but they couldn't answer whether there was anybody else in the apartment. Maybe Flores just obtained the heroin from his own personal stash in the apartment. But for the latter sale, you have both the more active role by Reed and the exclusivity element, where he's the only person in that van that can be the drugs to Flores, who's then going to go and give them to the police officers. I also think that it's important to note, this court in State v. Thompson recognized that it's only in rare circumstances where a defendant's reflection can be established with direct evidence. And because Reed didn't testify in this case, which it's his right not to do so, the state is left with circumstantial evidence to prove its case. And that's not a failing on the state. The state's properly allowed to rely on circumstantial evidence to prove its case. And when you look at the fact that Flores is a known middleman in the community, he's well known to Reed because he's his roommate. Reed's present at both drug sales. The officer specifically requests to buy the drugs from Reed. They ask for an amount that's not in Flores's, that's going to be in Flores's personal possession, but that requires Flores to reach out to Reed. And then Reed does in fact reach out, or Flores does in fact reach out to Reed and arranges the sale and tells Reed that he's coming with others to buy it. When you add those all together and you look at it, not only in the light most favorable to sustaining the jury's verdicts, but also just in the view of not reweighing it on our own on appeal, but just to see whether any rational fact finder could find that the elements were proven beyond a reasonable doubt. That evidence does collectively support the jury's verdicts in this case. It's for that reason that the state argued that more than sufficient evidence supported the jury's verdicts in this case, and that the court didn't need to reach into the Section 13-303A argument. Now, if we want to talk about the Section 13-303A argument, it simply doesn't apply in this case. If you want to look just factually at the opening arguments, the way the case was presented by the state, the closing arguments by both the state and the defense, nobody at any point in this case ever argued that Reed was guilty under this theory of accomplice liability. It was just never argued. The state's theory all along was direct accomplice liability, that he furnished Flores with these drugs and aided him with the intent to use Flores as a middleman to sell these drugs. But beyond that, the section is just not applicable. When you look at the section, and I'll read you the language specifically. It says that a person is an accomplice of such other person in the commission of an act, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. There's only one crime in this case where the state ever alleged that Reed was an accomplice, and it was the sale between Flores and Reed. If you look at the first transaction, Reed wasn't an accomplice to that transaction. He was a principal in that transaction. For Section 13-303A to apply, you would need to have a situation where A sold drugs to B,
and
then
the second transaction, though, is different. The second one, in theory, the jury could find that Reed just sold or transferred drugs to Flores. They not? And what's your response to Mr. Green's argument that if that's what the jury determined, then they could go to that last sentence in the instruction and say it's just a natural or reasonable consequence that Flores would turn around and sell the drugs?
Well, my response would, I'm sorry, did someone else have a question? Okay, my response would be that the language is not whether or not it's a natural and foreseeable consequence of his actions generally. It's whether it's a natural and foreseeable consequence of a crime that he was an accomplice to. And there was no argument that he was an accomplice to any other crime beside the sale between Flores and the officers. And that wasn't, in terms of the fact that Reed can argue that, well, Flores was acting on his own, he sold these drugs to the officers. That was an argument that was presented at trial, and the jury's verdicts reflect that they considered that argument and they rejected it. And I think it's important to note that given the jury's acquittal on the first count, we can see that the jury actually took their role seriously in this case in terms of deliberating the elements of the case and applying the instructions that were provided to them. And that's just further evidence that they operated rationally in this case. And when you look at the evidence, it sufficiently supported their verdict. If there's no further questions, the state asks that this court affirm Reed's conviction and sentence in this matter.
Now I think you're muted.
Yeah, counsel, I did have one question. On the instruction, what is the use of the natural and probable or reasonably foreseeable consequence theory? Is that really valid? Is that language ever valid?
Sure, that language could be valid in a different kind of case. If you had an instance where person A has a very large quantity of drugs and they sell it to person B, and then person B sells it to person C, then person A is an accomplice to the sale to person C. And now let's say, for whatever reason, person C sells it to person D. Now you're within the realm of a natural and probable or reasonably foreseeable consequence. But that wasn't the case here. If you go back and you look at the transcripts and you look at when the parties are discussing the jury instructions in this case, there really is no deliberation over this specific natural and probable or reasonable foreseeable language. It seemingly was just included as part of the standard RAGI on accomplice liability. And so while it was provided and it didn't apply in this case, let's just say for the sake of example that merely putting the language in there when it didn't fit the facts of the case may have been error. Well, because defendant didn't object below, he's restricted to fundamental and prejudicial error on appeal, and he can't meet his burden in this case of proving fundamental and prejudicial error because he can't prove any prejudice. All we can do at this point is speculate that the jury may have looked at that language and may have applied it, but such speculation isn't what prejudicial error is made of. When you consider those alongside the fact that no party actually argued this avenue of liability to the jury, the defendant doesn't get to the point of proving fundamental prejudicial error.
Thank you, counsel.
Thank you.
Mr. Green, rebuttal.
Thank you, Your Honor. You want me
to? There you go.
All right. Your Honor, just a couple of quick points that I would address in response to the state's argument. first and foremost, the state referred to Mr. Flores as a known middleman. And again, I don't think the record supports that other than the detective's actions of buying drugs from him. And it was the detective's testimony or assumptions that he was a known middleman. There was no evidence.
Well, but why can't the jury accept that testimony?
Well, they can accept that testimony, but I don't think it's supported by the record. I think the detectives can say that they bought drugs from this Mr. Flores a number of times, and they considered him to be a middleman, but there was no evidence to support the fact that he was an actual middleman or a known middleman to Mr. Reed. What the detectives testified to was we bought drugs from Mr. Flores numerous times. They didn't say that Mr. Flores got those drugs from other people every time. They didn't say they got them from Mr. Reed every time. What the detectives did was assume that he was a middleman because they would ask him for drugs and he would provide them. What the detective's testimony really was that Mr. Flores is a drug dealer to them. So it wasn't a known fact, excuse me, that he was a known middleman in this community. There was no additional evidence beyond what the detectives testified to establish that. Again, I will just rely on the fact that the state says collectively, when we look at all the evidence, there was sufficient evidence to establish that Mr. Reed was an accomplice to this. The record doesn't support that. When you look at the collective evidence, what you have is somebody giving drugs to Mr. Flores without any additional evidence to establish that those drugs were going to later be resold. Because of that, Your Honor, we would ask that the verdict be vacated and that this court enter a judgment of acquittal for Mr. Reed.
Thank you, counsel. Thank you both, counsel, for your argument today. We'll take this matter under advisement and we'll issue a decision in due course. Thank you very much. We stand adjourned. Thank you.